When did the Attorney General's office wake up?
My heart I've traded in. Some new stranger dwells within. Crazy circles are leading me back where I've been. So I'll start over again. Give until you give in. Pay the devil now to make amends, and I'll give all this back to you.
But the magistrates, in a case where there's not a waiver of a probable cause hearing, don't have discretion simply to elect, well, I'm not going to do a probable cause hearing for this defendant. They have the discretion, once they have the hearing, to decide it in a judicial way. Isn't that so?
Y'all. This here is William Troy Cates. And for those of you who ain't yet learnt, on March the 10th of 2010, the fool filed a motion for a bullet in the Circuit Court for Alabama's 14th Judicial Circuit. Yes, Sir Rebob, you heard me right. Mr. Cates filed a document, in a court of law, entitled Motion for a Bullet, in which, the dumbass hillbilly, self-identified as an increasingly radicalized potential lone wolf, and asked the presiding Walker County Circuit Judge, Jerry K. Selman, to require the criminally insane town of Parrish, Alabama, to put one or more high-caliber bullets into the base of Mr. Cates's skull. Among the many alternative demands, in Mr. Cates's motion, the first was for the boy to publicly thank the good Lord for not making William Troy Cates a gun-toting, potential lone wolf. Additionally, Mr. Cates told the boy to take notice of a long list of poorly articulated facts, which he believed could be proven and would shock the conscience of any honorable judge. More importantly, Mr. Cates begged for a remedy that would protect Mr. Cates's neighbors and local law enforcement officers from the municipal court retained by the criminally insane town of Parrish, Alabama. The naive hillbilly believed himself to be acting on the notion that honorable people took protective action when they see a real and present danger. So he felt obligated to attempt to tell, as best as he could tell, those honorable folks that something was extremely wrong with Nicholas Lee Smith's municipal court and their war. A war on drugs, wasn't it? The dumbass hillbilly gambled and lost the bet that Judge Selman was such an honorable person. All these years later, not only does Mr. Cates continue to publicly brag about having once defeated the false notion of seeing a just cause and reason for the preemptive use of deadly physical force against a particular Walker County municipal magistrate in defense of himself and others, but he is also, currently, calling for the federal prosecution of both the Walker County District Court Judge Henry Allred and the Walker County Circuit Clerk Susan Odom for their role in incarcerating, for 3 mother-frackin' days, Terry Keith Hammond, his daughter Terry Danielle Hammond, and another unnamed female, and intentionally depriving the 3 people of their federally protected right to a prompt judicial determination of probable cause and their right to be free from excessive bail.
But it may well be that at the time you were arrested there was no colorable basis for probable cause. And maybe for the first 3 days there was no colorable basis, or even the first 6 days. But then the state digs up enough evidence by the 7th day to establish that you could continue to be held. I don't consider that an additional protection. It means in effect you never do get it's too late. You've been held for 6 days without any justification.
We hold today that the information filed by the prosecutor, standing alone, is not sufficient to justify detention pending trial. Rather, the Fourth Amendment requires a fair and reliable determination of probable cause as a condition to any significant pretrial restraint on liberty. Moreover, this determination must be made by a judicial officer promptly following arrest.
Mr. Cates claims to have had direct communications with Terry Danielle Hammond, and of all the things little Miss Hammond trifled on about, the only thing relevant to the arrogant pricklet were D's few things right cheer. 1. That both her and her father were arrested on March 19, 2019. 2. That she filled out, signed, and dated an affidavit of substantial hardship while being booked into the Walker County Jail. 3. That her father, and another lady were transferred to the courthouse, on March 20, 2019. 4. While at the courthouse, she was Mirandized and questioned, by judicial officers, about a co-conspirator, her younger sister, prior to Judge Allred ordering the 3 detainees to return the following Friday, to have their bail set. 5. On Friday, March 22, 2019 they were transferred to the courthouse, had bail granted and an indigency determination was made. 6. Another lady in the same jail dorm as Miss Hammond, claimed to have been transferred to the courthouse multiple times for 2 months, until she complained about bail not being set. So Judge Allred set bail at no bail. Essentially, refusing to grant bail, and she was no longer transferred to the courthouse for those hearings.
Illegal commitment. Except in capital cases where there is no right to release on bail, no person or defendant shall be committed to any jail in the state of Alabama on a warrant, unless there is an amount of bail affixed to the warrant. No person or defendant shall remain in jail anywhere in this state for more than 24 hours for any felony or misdemeanor case without an order of bail, unless bail is not authorized by law.
Mr. Cates claims that the official court records state the following facts. 1. That each of the crimes the 2 Hammonds are accused of committing, occurred on March 19, 2019. 2. That Terry Danielle Hammond swore to her affidavit of substantial hardship before Judge Allred on March 19, 2019. 3. That a criminal complaint against each Hammond was sworn to on March 21, 2019. 4. That warrants were also issued for the arrests of both Hammonds, on March 21, 2019. 5. That both warrants state that bail was to be set at initial appearance. 6. A law enforcement officer executed both warrants by arresting and jailing each of the 2 Hammonds, at 10 minutes after 10 on the morning of March 21, 2019. 7. Both of the 2 executed warrants were filed with the circuit clerk's office at 10:54 on the same morning. Which just happened to be 1 minute after Judge Allred was assigned to one of the 2 Hammond cases and 1 minute prior to Judge Allred being assigned to the other Hammond case. 8. The new e-warrant system automatically uploaded a redacted warrant and complaint to the case action summary of one of the 2 Hammond cases at 10:55 and the other at 10:56 on the morning of March 21, 2019. 9. Judge Allred granted bail and made the indigency determination for both of the 2 Hammonds on March 22, 2019. 10. Terry Danielle Hammond made bail on March 22, 2019. 11. Terry Keith Hammond was unable to come up with the fully secured cash-only bail and was incarcerated when he allegedly made 4 terrorist threats against various Walker County officials, in retaliation for their participation in the judicial process.
Talk about that.
I love the new warrant system.
Okay.
It starts with the sheriff's office. The information is put in. It is brought to us. We review the information. A lot of people don't know, but we are the magistrates for the county. I'm the chief magistrate of Walker County.
Because they say go see the magistrate, and somebody says, well, who is it?
And that would be me.
And that would be you.
And
cool.
My staff, they're all magistrates. I have 2 of them that hear the warrants, hear the issues, and decide on the misdemeanor warrants. You know, if you have a little issue out in the county, not getting along with your neighbor, you know, somebody's dog bit somebody, anything that you need that, you know, think someone should be arrested for. You get a report, you bring the report, or the report is electronically sent to us. We review it, sometimes with the officers involved, a lot of times we do, get information, and we determine probable cause to issue the warrant.
I see.
And we do that now through the new warrant system.
Wow.
So we put the information in and we electronically send it back to the sheriff's office. They can pull it up and they can see all outstanding warrants, what needs to be executed, what doesn't, where it is. It's really a great system.
That is awesome.
Our judges can now do bench warrants from the bench.
Wow.
If someone ready to appear in court, they just put it in their computer and it's sent right to the sheriff's office.
Oh my gosh, and then the sheriff can go just right on out.
Right on out and get them.
Oh, you will be found.
That's right.
They can find us no matter what.
Yes, no matter
wow,
what.
You can't hide from anybody anymore.
No, we're quick with it.
Oh, yeah.
It's made it much nicer.
Well, that is great. So now y'all are pilots for that, or you've started that.
Yeah.
And then that'll be spreading out throughout the state.
Throughout the state.
And then what other things do y'all do?
Well, basically, the main job is maintaining the court files and the money for the court system.
Oh, I see.
Any fines, any court costs is paid through us, and we maintain it. We're audited. And I can proudly say we have had perfect audits. My employees, again, are very incredible.
That is awesome.
So, you know, I love an audit. I know that sounds crazy.
No.
But they not only audit us for the money, but they audit us for our work and how we put in the orders and how we process them.
Oh.
So we've always had perfect audits, no findings. And that goes back to that incredible staff. They are
excited
awesome.
to hear that.
You know, to be under 50% staffed and have the workload that they have, and to be able to process and do it so well.
Mm-hmm. Now, you have how many? Is it all ladies, or do you have men and women?
I don't think a man could work with us.
I don't think they could handle it. I don't know.
All of the stated facts are very consistent with known local customs, which Mr. Cates has observed, studied, and audited, for quite a long time. With the single exception for the fact that Allred's little Bama ass forgot to scribble over the date that Miss Hammond filled out and signed the affidavit of substantial hardship and replace it with the date he actually signed the affidavit. However, Mr. Cates appears to be deeply remorseful, and is actively begging you people to forgive him for not being smart enough to comprehend the fact. The actual freaking fact, y'all. That it is legally possible for the Walker County Circuit Clerk, Susan Odom, to conspire, criminally, with the Chief Magistrate of Walker County's District Court Magistrates, who also happens to be the very same Susan Odom, who is the duly elected Circuit Clerk. Had he known that an elected circuit clerk, in Alabama, could lawfully be employed as the head of an entirely different agency, department, or subdivision of the judicial branch of Alabama government, as long as the circuit clerk only receives a salary for one of his or her official state jobs and does the other, entirely different, official state job, pro bono. Mr. Cates would have done his very best to ensure that everyone within earshot of those gossiping grapevines were aware that folks have to accuse Susan Odom in each applicable official capacity, and properly articulate, with extremely accurate precision, an inter-corporate conspiracy between Susan Odom in her official capacity as the Walker County Circuit Clerk and Susan Odom in her official capacity as Chief Magistrate of the Walker County District Court Magistrates, to hold her civilly or criminally liable for any of the following. 1. Refusing to assign a case number and docket a criminal case, promptly after a warrantless arrest. 2. Refusing to make the required prompt judicial determination of probable cause, even when the sheriff's office presents a person arrested pursuant to a warrantless arrest to the court, in the open court of a regularly scheduled initial appearance hearing. 3. The 2014 administrative decision or decisions and/or agreement, which were knowingly and intentionally made with the willful intent to cause the false entry into the official court record, of the wrong arrest date and the wrong case initiation dates of all warrantless arrests. Thereby intentionally manufacturing the false appearance that each warrantless arrest was made pursuant to a previously issued warrant, and intentionally manufacturing the false appearance that a case number was assigned to each case and the case was properly docketed for an initial appearance, promptly after an arrest. William Troy Cates wholeheartedly believes this false entry, based on the false testimony of a local law enforcement officer, is the direct result of an administrative decision made in 2014, during the implementation of the new e-warrant system. William Troy Cates is alleging that this 2014 administrative decision was knowingly made with the intent to cause the false entry, into the official court records, of a false arrest date and a false case initiation date, and thereby continuing the unlawful practice of refusing to create case numbers for warrantless arrests until after local law enforcement grants permission to the district court magistrates. You can see the result of this administrative decision in the copies of executed warrants, filed as exhibits, in the federal court case against Susan Odom in her official capacity as Walker County Circuit Clerk and Supervisor of Walker County District Court Magistrates. Prior to the implementation of the new e-warrant system, Deputy Sheriff John Blair Huddleston would swear and attest to executing a warrant on the actual date of a warrantless arrest. Which, of course, was prior to the date of the issuance of the warrant. After the new e-warrant system was implemented, Deputy Sheriff John Blair Huddleston would swear and attest that he executed the warrant, the day of issuance. William Troy Cates is accusing Susan Odom of using at least 2 of her official capacities, Walker County Circuit Clerk, and Chief Magistrate of Walker County District Court Magistrates, to cause the false entry into the official court records, with the intent to aid local law enforcement in imposing custodial detentions for investigative and other purposes. This false entry could not have been achieved without the knowledge and consent of the circuit clerk, through her authority to establish the filing and training policies, which make it appear that the clerks had been deceived. Though, the aid does not appear to have been sought or needed, in establishing probable cause, for the warrantless arrests of the 2 Hammonds. Thus, making the delay in obtaining the prerequisite judicial determination of probable cause, a delay for the sake of delay, or in the alternative, a delay for the purpose of inflicting punishment, or in another alternative, a delay to aid the coercion or manufacturing of other evidentiary information. Which took full advantage of Judge Selman's desire to dole out as much pretrial punishment that he could get away with, in addition to the unreasonable delay created by Susan Odom's premeditated false entry. The suspected intoxicated typist will force me to explain the applicability of Judge Jerry K. Selman's 2017 standing order and its amendment, after this here community service announcement.